and welcome to PM IAS. This is the new initiative for the monthly magazine Current Affairs UPSC IAS 2024. So here you can watch this video with live session in every day. Here the first section of monthly magazine Current Affairs from Vision IAS. The section is the polity and governance. And first topic is the separation of power. Why separation of power? This separation of power given in the Constitution of India. That is the basic feature of the Constitution. Why was in news? The demand of executive representation in collegium system had started debate over doctrine of separation of power in Indian constitution setup. And why this separation of power? Because the separation of power is given in the constitution. That is the power distribution between the legislative, executive and the judiciary. And this separation of power was evolved in the past since the constitution was framed. Recently, the Ministry of Law and Justice in his letter has suggested that union government representatives be included in the Supreme Court Collegium and state government representatives in the High Court Collegium. Before ongoing the separation of power, I want to tell you that this is the January 2023 monthly magazine of Vision IAS. So you can watch this video to cover whole current affairs throughout the year. And I will cover more than 15 or 16 months current affairs based topics through these monthly magazine subjects. Okay, so here we start from here. The vice president also stated that he did not subscribe to the landmark Kesavananda Bharati judgment of 1973, which had propounded the basic feature of the constitution. And this basic structure upheld judicial review and limited the parliament's power under given Article 368 to amend the constitution. And Supreme Court bench on delay in appointment of judges recommended by collegium stated that under constitution law declared by the Supreme Court is binding on all. So here you can watch the video, the basic structure of the constitution. Okay, search in the description and you can find this video about the basic feature of the constitution, how and why it evolved since the constitution was framed. Here you can see here that separation of powers between the executive government and parliament and the judiciary. Executive government and parliament to make and change law and introduce law in the parliament by the legislature, and executive the works of executive to execute and power to put law into action, and What is the work of judiciary? That scrutinize those law those laws which are framed by the parliament and execute by the government. Okay, so here this is the separation of powers between these three organs of the government, and this separation of powers under each of these institutions can check the others. These institutions can check each other's scrutiny and final scrutinize by the court to every law and rules and regulations which are created by the parliament. Although absolute and rigid separation of power does not exist in the constitution, okay, that separation of powers is not anonymously mentioned in the constitution. Certain articles do indicate towards separation of powers. The basic of constitution as per Keshavananda Bharati case, which is the cardinal doctrine to generate the separation of powers between these three organs, an overlap of the powers and responsibilities between all the three organs of the state manifested. Under the absolute and rigid separation of power does not exist in the constitution, certain articles that are Article 50, which is mentioned in the DPSP, Directive Principles of State Policy, which directs the state to separate the judiciary from the executive. And Article 361, immunity of the President and Governor from the civil and criminal proceedings wherever they are in office. And Article 105 and Article 194 mentioned that no member of parliament and legislature, member of legislative assembly can be indulged, can be arrested about the civil and criminal procedures, and power and privileges and immunity for these member of parliament and member of legislative assembly, MPs under Article 105 and member of parliament, that is MLA under 194, and Article 122 and 212. These articles prohibit courts to inquire into the proceedings of parliaments or state legislature. And under Article 13 that mentions the judicial review, that any amendment taken by the parliament by law, any law which is under Article 13 made by the parliament will be declared null and void by the court. And under Article 32 and 226, the right to constitutional remedies. Under Article 32 given that any individuals which is violated by any others or state, the individual can go to the Supreme Court directly without any appeal with the any High Court of India. And under Article 226, the any individual's fundamental rights violation, that he can go to the High Court for the violation of his fundamental rights, and any statutory rights other than the fundamental rights, any individual can go to the High Court for their violation of the ordinary right and fundamental rights. Okay, so here the constitutional remedies are uh, more than more with the high court than the supreme court. Okay, because supreme court only resolves related to the fundamental rights, whereas the high courts can resolve the case besides fundamental rights. Okay, and under article 142, here the extraordinary power to the supreme court to do complete justice. Okay, so you can remember this. And historical background of the separation of power concept was first seen in the works of Aristotle. Aristotle in the 4th century BCE declared that the three agencies of the government as General Assembly, public officials and judiciary, and that organs were taken from Aristotle's agencies, that these separation of powers are mentioned and created in the constitution. In modern times, it was 18th century French philosopher Montesquieu who made the doctrine a highly systematic and scientific one in his book T Spirit de Laws, the Spirit of Laws. So you can remember Montesquieu's book, The Spirit of Laws. And importance of separation of power in India. Protection of citizen right. You can remember for means perspective that protection of civil citizens rights, judiciary being final interpreter of constitution, protect the rights and liberty of citizens. For example, the nine judge bench of the Supreme Court in K.S. Putta Swamy versus Union of India case unanimously reaffirmed the right to privacy as a fundamental right under the Constitution of India. And second is prevents abuse of powers, as powers are distributed among different institutions, that is the executive, legislative and the judiciary. These institutions enjoy only limited powers, which prevents rise of dictatorship or anarchy and promote constitutional supremacy. So you can remember. And third is the ensure judicial independence. The separation of power helps to strengthen the independence with which the judiciary has to perform its functions and functional specialization. Under this functional specialization, among different institutions, ensuring efficiency in the government and minimizes conflict among government institutions. There are fairly well defined boundaries as well as judicial review to deal peacefully with any source of friction between any two organs of the government. Okay, and what are the issues in this separation of power in India? First issue is deadlocks between the executive and the judiciary. Why the deadlock between these executive and the judiciary? Because the appointment of CJI in the collegium system and judges of the apex court is governed by a memorandum of procedure which was issued in 1947 and updated in 1999 under the third judge's case. Judiciary struck down National Judicial Appointments Commission in 2015, and court told the center in 2015 to come up with a new memorandum of procedure in order to make the collegium's proceedings transparent. And in 2017, the memorandum of procedure was finalized but was not adopted. The government said it was reconsidering the issue. And next issue is challenges in division of functions, because the government sometimes overpower their rules, even overpower the judicial scrutinization in making the laws. This division of function doctrine is based on the assumption that the three functions of the government are independent and distinguishable from one another, which is mentioned in the directive principles of state policy. In practice, there can be an overlap in their functions and powers, leading to conflicts and challenges in adhering to the separation of powers principle. For example, if the legislature can only legislate, it may face difficulties in punishing someone who commits a breach of its privilege, as it could be seen as a quasi judicial function, leads to encroachment of other organs. The fourth issue is leads to encroachment of other organs. Modern interpretation of the doctrine recognizes incidental functions by one organ without encroaching on essential functions of another organ. However, there is a risk of encroachment leading to power struggle, undermining the principles of separation of powers. And here you can see here the previous or the judicial pronouncement on separation of powers. Keswananda Bharati versus State of Kerala. The Supreme Court held that the amending power of the Parliament is subject to the basic feature of the Constitution. So any amendment violating the basic features will be declared unconstitutional and void. And further, the IR Coelho versus State of Tamil Nadu doctrine of basic structure as propounded in the above mentioned case and the ninth schedule grant blanket protection to certain legislations from judicial review is violative of this doctrine. Ram Javaya Kapoor versus State of Punjab. Here, this basic structure mentioned by the court and held that the Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity, but the functions of the different parts or branches of the government have been sufficiently differentiated. And Kanna Sadan versus State of Tamil Nadu further court stated that the Constitution has invested the constitutional courts with the power to invalidate laws made by the Parliament and the state legislatures, transgressing constitutional limitations. And further, in the Golaknath case versus State of Punjab in 1967, it was observed that the three organs of the government are expected to exercise their functions within their limits and keeping in mind certain encroachments assigned by the Constitution. That in this case, the Supreme Court held that each of organs of the government is functions separately and not encroachment each other's cases or functions. And further, Kartar Singh versus State of Punjab, the court held that it is the function of the legislature to make the law, the executive to implement the law, and the judiciary to interpret the law within the limits set down by the Constitution. Okay. And affordable and accessible justice. What is this the affordable and accessible justice. You can see here the this you can remember the court judgmental in Anita Kushwaha versus Pushpa Sadan 2016. The Supreme Court held unanimously that life includes physical as well as bundle of rights that also means right to access justice. In this case, there are four components include effectiveness of adjudicatory mechanism, speedy adjudication, reasonable accessibility in terms of distance and affordability of the mechanism, and steps that can be taken by the judiciary from this case. The standardized and regulated fees of lawyers, establishing National Judicial Infrastructure Corporation, promoting alternative dispute resolution, and promoting digital infrastructure. So you can remember these four infrastructural development have been taken by the court proceedings. And what is need of this affordable and accessible justice? Because affordable legal representation, the higher fees of top lawyers of Supreme Court and higher court reduces affordability. Addition to the court fees, spend nearly 25% above the court fees. Lack of awareness, only 12 lakh persons benefited in around 80% of population under free legal aid. Low budgetary allocation. Average spending on the judiciary was to merely 0.08% of GDP between 2011 to 2016. So you can remember this. And what are the way forward? That the case resolved under the separation of powers between the legislative, executive, and the judiciary. It needs to promote proper checks and balances between various institutions such as these three organs of the government, and timelines in PLR projects Limited versus Mahanadi Coalfields Private Limited case in 2021. Supreme Court stated that the recommendations by the Collegium must be cleared by the Centre within 3 to 4 weeks to avoid any deadlock, and promoting constitutional supremacy by focusing welfare of the citizens. More on news. The National Judicial Commission Bill 2022 was introduced in the Parliament or introduced in the Rajya Sabha in 2022. Okay, National Judicial Commission Bill 2022 aims to regulate the appointment of judges to the High Courts and the Supreme Court through the National Judicial Commission. You can remember this National Judicial Commission is the co-order of the Union Public Service Commission. In such case that UPSC conducts the recruitment process through the Union Public Service Commission Civil Services, and this National Judicial Commission will conduct its own exam to recruitment of the candidates of the judicial process. So you can remember. And what is the demand of this bill? Bill seeks to regulate the procedure to be followed by National Judicial Commission for recommending persons for appointment as the Chief Justice of India and other judges of the Supreme Court and Chief Justices and other judges of the High Courts for their transfers, and to lay down judicial standards and provide for accountability of judges, and establish credible and expedient mechanism for investigating into individual complaints for behavior or incapacity of a judge of the Supreme Court or of a High Court, for the presentation of an address by Parliament to the President in relation to proceeding for removal of a judge. And next is the federalism. This is very crucial for the UPSC mains as well as prelims perspective. Why federalism? Because recently a tussle between the Union government and the Union territory of Delhi due to overlapping of functions affecting routine administrative work in Union territories. Supreme Court in this case going on the tussle between the Delhi government and the center over administrative control of postings and transfers of civil servants belonging to all India services serving in Delhi. The central government stated that a union territory is nothing but an extension of the Union of India. Due to this, the further government of India introduced a bill with the help of the ordinance of the president. So here the National Capital Territory of Delhi Amendment Rules Amendment Bill introduced by the Parliament to create the services under the National Capital Territory of Delhi government. Important Supreme Court judgments. GNCTD versus Union of India case 2019. From this case, two judgments of the Supreme Court had delivered a split verdict on the question of powers. National Capital Territory of Delhi and the Centre over services and referred to the matter to a three-judge bench. Government of National Capital Territory of Delhi versus Union of India case. The Lieutenant Governor would be bound by the aid and advice to the Council of Ministers in matters that were not directly under the control of the legislative Lieutenant Governor. Barring police, public order and land, the Lieutenant Governor's concurrence is not required on other issues. However, the decisions of the Council of Ministers will have to be communicated to the Lieutenant Governor. Okay. And present status of Delhi as Union Territory. The 69th Amendment of the Constitution in 1991 gave the national capital of Delhi special status with its own democratically elected government and legislative assembly. So you can remember for prelims perspective. Okay, the 69th Amendment Act of the Constitution in 1991 was created. Then Delhi was replaced by the National Capital Territory of Delhi, that is NCR region. Insertion of new articles 239 capital AA and 239 capital AB after Article 239A of the Constitution. In this article given under Article 239A, which is related to the Union Territory of Puducherry, and these articles, Article 239A and Article 239AB, are given for the National Capital Territory of Delhi. So you can remember. The Legislative Assembly shall have power to enumerate anything in the state list or in the concurrent list, insofar as any such matter is applicable to the Union Territories, except matters with respect to entries 1, 2 and 18 of the state list and entries 64, 65 and 66, that is police, public order, and land of that list insofar as they relate to the said entries 1, 2, and 10. In list in entries 1, 2, and 10 gives the police, public order, and land to the authority of the central government, and this provided that in the case of difference of opinion between lieutenant governor and his ministers on any matter, the lieutenant governor shall refer it to the president for decision and act according to the decision given thereon by the president. Public order, police, and land in NCT of Delhi fall within the domain of the union government. Government of National Capital Territory of Delhi, that is NCTD, GNCTD 2021 Act was passed. The term government in any law made by the Legislative Assembly shall mean the Lieutenant Governor. The Lieutenant Governor's opinion shall be obtained before the government takes any executive action based on decisions taken by the cabinet or any individual ministers. So you can remember, the Lieutenant Governor will not assent to and pass on to the President for consideration any bill which incidentally covers any of the matters which falls outside the purview of the powers conferred on the Legislative Assembly. And what are the issues between the Union Government and the Union Territory of Delhi Government against the privilege of the legislature? Framing the rules to conduct its proceedings is thus a part of the privilege each house of a legislature enjoys. No accountability of Lieutenant Governor action. No rules shall be made by the Assembly to conduct inquiries in relation to administrative decisions. Executive accountability is the essence of the parliamentary system of government, which is a part of the basic structure of the Constitution. Undermining the elected government. The Lieutenant Governor, who will be the government, is under no obligation to implement any law passed by the Assembly or carry out the directions of the House, as he is not responsible to the Assembly. Concentration of power. There is the issue of concentration of power as stated in the Government of National Capital Territory of Delhi Act. The term government in any law made by the Legislative Assembly shall mean to the Lieutenant Governor. So remember this, okay, that every government action would be in the name of the Lieutenant Governor. Under Article 239 AB provides for President's rule in Delhi when the administration of the territory cannot be carried on in accordance with the provisions of Article 239 capital AA. President's rule is imposed on a report from the Lieutenant Governor. If the Lieutenant Governor is the government, will she or he have to make a report against themselves. So here the Lieutenant Governor has punishment as well as his authority to inform the President to imposition of the President rule or not with the accordance of the Constitution. And against cooperative federalism, the Act not only negates cooperative federalism but also upturns the fundamental principles laid down by the Supreme Court in Government of NCT Delhi versus Union of India case 2018. So you can remember this. Control over services department. The governance has always been contentious issue since Delhi is not a full state and the services department comes under the Lieutenant Governor's jurisdiction. Difference between Lieutenant Governor power in Delhi and Puducherry. The Lieutenant Governor of Delhi enjoys greater powers than the Lieutenant Governor of Puducherry. The Lieutenant Governor of Delhi has executive functions, that is the functions of the government that allow him to exercise his powers in matters connected to public order, police and land in consultation with the chief minister if it is so provided under any order issued by the president under article 239 of the constitution. Lieutenant Governor of Delhi is also guided by the GNCT-D Amendment Act 2021 and the transaction of business of the government of National Capital Territory of Delhi Rules 1993. The Lieutenant Governor of Puducherry is guided mostly by the Government of Union Territories Act 1963. Article 239 and 239 AA of the Constitution as well as the GNCT-D Act 2021 clearly underline that Delhi is a union territory where the center has a much more prominent role than in Puducherry. So you can remember this comparison between union territory of Delhi and Puducherry and how this federalism issues are resolved through effective measures such as collaborative structure. The apex court, that is Supreme Court, had rightly concluded that the scheme set out in the Constitution and the Government of National Capital Territory of Delhi Act 1991 envisages a collaborative structure that can be worked only through constitutional trust. Adopting fine mixed balance, considering special status of the Delhi and fundamental concerns as Delhi being the national capital, reducing politicization, not politicizing issue as a struggle for power between two political parties as it is ultimately an attack on the ideas of representative governance. Clear interpretation, a clear interpretation of the existing laws in the larger interest of representative democracy would suffice as has been established. Okay, so you can remember this about the federalism in India. Okay, and next is the elections and technology. So here we will understand this elections and technology in the next class. Okay, so thank you for watching. Have a good day.